Public Affairs very much thanks Residco, our sole corporate underwriter, for helping to make the production of this show possible.
There's a lot of women who have psychological scarring, if you will, emotional scarring, even spiritual scarring as a result of having an abortion. Do they tell you that? Do they tell you how many women are now on antidepressants, or how many women have considered suicide or have realized suicide as a result of that decision they made? Of course they won't tell you.
So you think this information should be provided to the woman as she's deciding whether she should go ahead and have the abortion? That's your argument.
Absolutely. I have a study here I'd like to cite from the Journal of American Physicians and Surgeons, okay? And it says, this was a study done in 2018, that many women, 67.5%, said that the decision to terminate their pregnancy was one of the hardest decisions they ever made in their life. It doesn't come easy. This is not an easy choice. Planned Parenthood would have you think it's like getting a tooth pulled or a gallbladder out. It is not. This is significant because most women, according to the study, 66% of the women knew in their hearts that abortion was wrong.
People want to know. They want to know how an attorney general who does know the law, how a governor who does know the law can have such divergent views, okay, as to the federal court says that federal courts are deeply skeptical of laws that distinguish among different speakers, allowing speech by some, but not by others, allowing speech by the folks who are pro-abortion, but not by others who are opposed to that. That's not me saying that. That's Judge Johnston. Do you think there could be any legislation that would be constitutional, that would be legal, and still deal with this matter?
I don't believe so, because it is violating multiple parts of the First Amendment: speech, exercise of religious liberty, the freedom of association, and then the 14th Amendment, equal protection and due process. That it violates the Thomas More Society complaint had 6 points in their complaint, and those are 5 just from the Constitution that I just gave you.
I would think the Attorney General, who certainly went to law school, he certainly knows what I've just said. We'd invite the Attorney General to come on and counter that and tell me, oh no, Mr. Berkowitz, you got that wrong. We have just as much right to regulate these views as we do people selling parts that be used in a machine. And the governor himself went to law school. He didn't practice law, but he gave a few $100 million, I think, to Northwestern University, and it's now the Pritzker School of Law. So I think he must know this. So come on, Governor Pritzker, explain where Dave Smith got this wrong, where Jeff Berkowitz got this wrong, and the others who disagree. I mean, we believe in free speech. Well, we're here with Dave Smith, Executive Director of the Illinois Family Institute. We're taping this on August 28th. And a major issue that has not been discussed a lot, I don't think, in the media is what's going on with abortions, what's going on with clinics, pregnancy crisis centers who are opposed to abortions and want to express that point of view, and what's going on with the Attorney General and the governor. Are they trying to suppress those views? Dave, let's just start with what's the status of abortion in Illinois in terms of, are women still going and getting abortions, and what are you and your organization trying to do about that?
Well, are women still getting abortions in Illinois? Absolutely. What's going on with the status of abortion? It's more than ever in the state of Illinois. Since the Roe v. Wade was overturned and the Dobbs decision came down, we have seen Illinois quickly move to become an abortion destination point of the Midwest. The neighboring states around us are all restricting abortion to one extent or another. Indiana just had their Supreme Court weigh in and confirm that they can ban abortions. And so Illinois is a dumping ground, if you will, or a destination point. And the abortion industry, which we call Big Abortion Inc., is expanding as fast as they can to accommodate anyone coming from these other states, including, for example, Flossmoor is a new clinic, Planned Parenthood clinic, opened up, and that is not too far away from Gary, Indiana. There's a new clinic opening up in Rockford, not too far away from Milwaukee. There is a new clinic opened up in Fairview Heights, Illinois, not too far away from St. Louis, Missouri. And there's now a number of abortion clinics opened up in Carbondale. And you would think at first, oh, that's for the college kids. No, it's for Kentucky and Tennessee, because they can put people on the Amtrak and send them on up to Illinois to have their children aborted. So grassroots organizations like Illinois Family Institute, like Pro-Life Action League, Illinois Right to Life, other groups, 40 Days for Life and such, are out on the streets going directly to the clinics and to the women in a crisis pregnancy, trying to make appeals to them to make the choice in favor of life. Don't choose abortion, but choose human life.
Basically, Illinois has a Consumer Fraud Act legislation, has for quite some time, applying to commercial entities. Now, some people refer to this as the Illinois Deceptive Trade Practices Act, but the Illinois General Assembly contemplated and did pass legislation that seeks to give another tool to the people who want to promote abortions, or at least promote a woman, as they might put it, a woman's right to choose to have an abortion, another tool to go after the pro-life clinics, and the pro-life clinics' view, and we'll see what the judge had to say about it in a second, they want to chill that discussion. They want to chill free speech. Okay, what do you know about that statute? Were you involved in trying to do anything to prevent the legislature from passing the amended Illinois Deceptive Trade Practices Act?
Yes, we worked against Senate Bill 1909. We lobbied against it. All the Republicans voted against it. Many Democrats voted against it, but they passed it because they have supermajorities in both the House and the Senate. And we know Governor Pritzker is pro-abortion, pro-Planned Parenthood, and he signed it into law. But, let me just back up just a little bit, because, in the years preceding, running up to the overturning of Roe v. Wade, we saw our legislature work tirelessly to dismantle all abortion restrictions in Illinois, everything. So it was fair to say in the last election that Illinois Democrats support unrestricted abortion on demand all the way up to birth. And none of them would deny that, especially J.B. Pritzker. But that was not enough, which is really the point here. That was not enough. They cannot tolerate that.
Let me just stop to just clarify something. So when you say unrestricted up to birth, is it your contention that any woman in Illinois who wants to have an abortion a day before she's due can do that? People refer to those as late-term abortions. Those are really late-term or partial birth abortions. Are those still totally legal in the state of Illinois?
Absolutely, absolutely, absolutely legal. Before,
do you know if that's the case outside of? Do you know if that's the case outside of Illinois and other states, or depending on the states?
I'll give you, California, Pennsylvania, New York, yes, but not in the red states. Not in, and you know what? Ironically, you bring this up. Not in many countries around the world. Most countries around the world have at least a 12-week, if not a 15-week ban on abortion. You cannot have, in a 40-week pregnancy, you cannot abort a child past the 14th, 15th, 16th week of gestation. But
so that's about a four-month limit. When a woman has been pregnant for more than 4 months, in most countries, you're saying they are not allowed to have an abortion, and in many states in the United States, they're not allowed to. But in Illinois, a woman can have an abortion anytime she wants to.
That's right.
Up to the time of birth. Is that right?
That's right. That is correct. That is correct. All the way up, and most people don't understand that. And in a poll that we did before a couple of years ago, we were part of it, group of pro-life groups. 70% of Illinoisans, voters here in Illinois, want some kind of restriction. But our legislature, our governor signed it into law that it would be totally unrestricted. And they even took away the Parental Notice of Abortion Act, which was held up in court for 20 years and then finally went into effect maybe a decade ago. But they took that down. They rescinded that law, which merely said that if a minor child was going to get an abortion, that the parents or grandparents, guardians had to be notified, not consent. No consent was required, but notified. They couldn't tolerate that. And so now we're at this point where you're asking me about the Senate Bill 1909, which prosecutes crisis pregnancy centers. You might say it's the only alternative to Planned Parenthood in the abortion industry. And so they cannot abide the fact that these abortion ministries, these crisis pregnancy centers, are actually helping women make choices for life instead of abortion. And the abortion industry wants to make money. It's all about money. It's not about helping these women. It's all about making money. And so they cannot abide the fact that these women are making choices for life instead of abortion. And that's where we are today.
So what is, in your view, what is a Senate Bill 1909?
Yes.
What does it do? You've said it punishes these pregnancy crisis centers. What does it do to punish them?
So according to Kwame Raoul, our Attorney General, who has supposedly helped draft this bill, he says that any misinformation being propagated by the crisis pregnancy centers or even sidewalk counselors can be legally prosecuted and fined up to $50,000 per incident. And if you know anything about these small crisis pregnancies or pregnancy resource centers, they really have a shoestring budget. They have mostly volunteers working for them. Most of their resources go into diapers and clothes and food and educational material for women who are in a crisis. And so a $50,000 fine could put many of these resource centers out of business, or if there's two in a row could put them out of business.
But what would the fine be levied for? What are the acts that are prohibited that you're saying the Attorney General would allege and then try to prove that these crisis centers are doing in violation of the amended Consumer Fraud Act?
So some of our pro-life lawmakers in Springfield asked the sponsor of the bill during debate that very question. What do you consider misinformation? Kwame Raoul's staff said, well, we'll determine it by case. And so some of the lawmakers asked questions. Would it be misinformation to tell a woman that human life begins at conception, right? And of course, they avoided that. But see, it's a worldview.
They avoided giving an answer. They said something like, we'll look at all of the circumstances, right?
That's right.
They didn't give an answer to that question.
They avoided answering that question, but you can see it's a worldview question. And if a left-wing attorney general like Kwame Raoul is defining the terms, he gets to define the terms of what is misinformation, what is true, what is not true, then pro-lifers are in big trouble. But he's not the arbiter of truth. There is real science here that they're denying, you might say. They are denying science when it comes to the issue of when life begins. And
very succinctly, what does the science say about when life begins?
Well, when life begins, a totally unique human being with its own DNA, unique DNA, its own blood type, its own fingertips starts to grow. It grows, the cells multiply and start to form. In over 40 weeks, a distinct human being is formed in the womb. The Bible would say knit together in the mother's womb. That's what God says. I knit you together in your mother's womb, and you are a distinct human being with your own DNA.
Excuse me, but see, you would say, and your followers and those who were part of your organization would generally say that life begins at conception, life begins when the egg is fertilized. Is that right?
Absolutely. And that is our religious
And would you say when you
scientific
have a fetus,
conviction.
let me just ask you, when you have a fetus or the beginnings of a fetus,
Yes.
which I guess is at conception, do you have a human being there? Is that your view? And do you know if there's a law? Does the law say that that's a human being? What's your understanding?
I don't know if the law says that. I don't think anywhere it says that. I do know that even in Illinois, if you kill a woman and her unborn baby in a crime, you can be prosecuted for 2 murders. Okay, so in a way, the law does recognize the fact that there is a distinct human being in the womb, but it is our religious and scientific conviction that life begins at conception. And of course, we're Americans. We have a right to believe in these things and to promote these things in the public.
What gives you that right? Excuse me, what gives you that right?
The First Amendment of the Constitution. Freedom of speech, freedom of religion, freedom of association. So all those things give us, those are 3 of the 5 freedoms of the First Amendment that get, and of course we can stand on any one of those to be able to do this. So
in your view, in your organization's view, and the others who you know who are viewed as pro-lifers, would you say that you have that First Amendment right? And this law that was eventually passed by the Illinois General Assembly, would you say that violates your First Amendment rights?
Absolutely. It actually.
And do you know, has that gone to court? And what was the holding of the court? You familiar with that?
Well, yeah. So it went up to a federal court in Rockford, and Judge Ian Johnston ruled in favor of the plaintiffs. That's the Thomas More Society, Peter Breen, former state representative, making the case for the pro-life side. And the Judge Johnston, said there's enough evidence here to put this law, to enjoin the law. So the law is not in effect yet, even though that's what J.B. Pritzker intended. The law is now put on pause until it can be thoroughly vetted and go through the judicial system.
Well, so what happened there was, you said in Rockford, that was a lawsuit filed by Peter Breen was the counsel, Thomas More,
right.
Thomas More Society. I don't know if they were one of the plaintiffs, but they were sort of supporting that Peter Breen is employed by the Thomas More Society, and he was the counsel for the plaintiff in that case. That was filed in the Northern District of Illinois, but the Western Division is in Rockford, where Judge Johnston sits.
Right.
And Judge Johnston, as you've alluded to, maybe just said, held, because the plaintiffs in that case were seeking a temporary restraining order, a preliminary injunction, and a permanent injunction, and filed a verified complaint. And they got more than a temporary restraining order. The judge issued a preliminary injunction, right? And the preliminary injunction said that law was unconstitutional, and it was a very strongly worded opinion, about 14 pages. And Judge Johnson quoted the late Justice Anthony Scalia, and said, Justice Scalia once said that he wished all federal judges were given a stamp that read stupid but constitutional. Okay, but the judge said in this case, Judge Johnson, Senate Bill 1909 is both stupid and very likely unconstitutional. And so it's a preliminary, issued a preliminary injunction, and that court will then come back and hear the full case, at which time it'll decide whether it's about to issue a permanent injunction. But for now, that effect of that preliminary injunction is they cannot proceed. The Attorney General cannot proceed and charge these individuals that you're talking about, the pro-life counselors, with violations of the law. We'll have to come back and see if they can get that preliminary injunction lifted. So the burden now, in a sense, is on, well, the burden is always on the plaintiff to prove its case, but for the moment, that stuff stops. People at this moment, they unless that law is validated, unless that preliminary injunction is upset, I think most of these people at this point can rest assured they shouldn't have their speech chilled because they don't have an imminent threat of a $50,000 fine, which they were worried about. Do I have that right?
That
as
is
far
correct.
As you know. I know you're not practicing law, but you know something about this.
Oh, no, absolutely. And can I tell you why it's so significant?
Sure.
Well, I have lots of friends who are in this ministry of sidewalk counseling. And of course, they would be also affected if this law was to go into effect. But I have a friend named Juan who is downtown Chicago in front of one of these Planned Parenthoods every day, praying, handing out Bibles, giving gospel messages, and also talking to the women going into the abortion clinic. And last month, he reported in July, I'm going to say, they reported that 10 women turned around and walked away instead of going into the abortion clinic. In other words, they changed their mind. So there's 10 lives saved at that one abortion clinic. Now you multiply that all over the place at all these abortion clinics where you have either prayer warriors or counselors out in front. And by the way, prayer warriors are very important as well. They're out in front silently witnessing, praying that the women would have a change of heart, and that even the doctors would have a change of heart, or the medical staff inside. I have a study here I'd like to cite from the Journal of American Physicians and Surgeons, okay? And it says, this was a study done in 2018, that many women, 67.5%, said that the decision to terminate their pregnancy was one of the hardest decisions they ever made in their life. It doesn't come easy. This is not an easy choice. Planned Parenthood would have you think it's like getting a tooth pulled or a gallbladder out. It is not. This is significant because most women, according to the study, 66% of the women knew in their hearts that abortion was wrong. But if you go up a little bit, 70% of them say that they got some pressure from somewhere, and a good number of those were significant pressure from boyfriends, spouses, parents, or others to have an abortion. The Planned Parenthood people, the pink hat people, like to say if you don't have a uterus, you shouldn't speak. Men shouldn't have a say in all this. Yet we've got boyfriends and spouses, husbands, maybe other people in the life of this young woman, this woman who's in a crisis pregnancy, who is pressuring her, saying, "Hey, I don't want to be a dad. I don't want to have responsibility. Go ahead and terminate the life of your unborn child." That flip side you will never hear from the mainstream media or from Planned.
This is clearly viewpoint discrimination,
Absolutely.
Content discrimination. So, on the one hand, if you're an abortion provider, you're basically immunized from saying whatever you want. On the other hand, if you're opposed to abortion and you're trying to provide this information, the law allows the Attorney General to scrutinize what you say, and he can decide what he thinks the truth is, and he can sue you under this law if they didn't have the injunction. He could sue these folks, the pro-life counselors, for saying things that, in their view, are distortions, are not true. So we don't have the marketplace of ideas and the data and the science adjudicating this. We have the Attorney General and the Governor J.B. Pritzker, very much behind this. So they are making these decisions. And basically the court said this is just a blatant violation of the First Amendment, and that's why they issued this preliminary injunction. And it's gotten almost no notice in the mainstream media that this has happened.
And to your point that you're making there, what does it say that a whole industry and a group of pro-abortion politicians want to shut down and punish dissenting voices that run contrary to their worldview? It is a worldview issue. So what does it say? That they're so intolerant of others' opinions, other voices, other truths, if you will, being in the marketplace of ideas, or what I would say the public square. It's I would label it tyranny, despotism.
The law makes clear a distinction between commercial speech, you're selling a car.
That's right.
And what we'll call opinion on public policy, which may use data, but it's a public policy kind of debate as opposed to commercial speech. And the law is much stronger in protecting that opinion and those speeches on public policy issues, on political issues, on debates. The federal court says that federal courts are deeply skeptical of laws that distinguish among different speakers, allowing speech by some, but not by others, allowing speech by the folks who are pro-abortion, but not by others who are opposed to that. That's not me saying that. That's Judge Johnston. He says speaker-based laws runs the risk that a state has left unburdened those speakers whose messages are in accord with the government views. Governmental discrimination among viewpoints, again, Judge Johnston, is a more egregious form of content discrimination. So
it's the weaponization.
He's basically saying you couldn't find a clearer example. That's why he said at the beginning of his statute, he said this was unnecessary because you have a Consumer Fraud Act that they could try to apply and make the arguments it applies to what's being said about abortion. So that's why he said stupid, it's unnecessary. And I think the Attorney General, in a sense, admitted that. But it's unconstitutional for all the reasons that Judge Johnston says. You cannot have content discrimination. And when you restrict speech, you cannot have viewpoint discrimination. Where does it go from here? This preliminary injunction has been ordered. This is now the law, essentially, in the state of Illinois, that that the law that was passed, Senate Bill 1909, is not the law at the moment. And now the court will hear the full case. And now the plaintiffs will put on their case. There'll be discovery. There'll be exchange of documents, depositions, and then it will go to a bench trial because there's a matter of equity here, an injunction. So it's going to be probably heard by this judge, and then it will be a decision by the judge. And then if the Attorney General still thinks that that ruling is unjust and improper, he can appeal that to the Circuit Court, to the Seventh Circuit Court of Appeals. And then if he's still losing, he can appeal it to the U.S. Supreme Court. You're from this area, right? From the state of Illinois.
Yeah, right? I grew up on the South Side in Mount Greenwood. My dad was a Chicago fireman. I went to mostly public schools. I graduated from Morgan Park High School, and then eventually went to UIC, where I finished out my degree and was a political science major, and then went to work for an alderman in the city for 7 years. And then found myself in a little hot water and with the media, that is, because I went after a shock jock named Mancow. But then I've been with the Illinois Family Institute since 2003.
All right. So 20 years there, 18 years as the Illinois Family Institute's executive director.
Let me just clarify. So I believe the push for this kind of legislation is motivated by money. Now, are they ideologically committed to the pro-choice, the pro-reproductive health, quote unquote, point of view? Absolutely. I'm not saying that they're not. It is absolutely a worldview issue. They believe that the right to life is subservient to the right for reproductive health care. So the right to kill a human being, a unique human being, is more important than the right to life. And many of us who are Christian or religious, we're talking Jews and Muslims and Hindus and many other denominations, Buddhists, who believe that, abortion takes a human life.
Hope Dave Smith will come back. Hope the governor will join us and the Attorney General. And folks, you come back next week and every week to Public Affairs.